What legal protections apply to traditional cultural expressions? Imagine a world where your cultural stories, art, or music could be shared freely without anyone claiming them as their own. That would be unfair, right? Protecting cultural expressions is important to keep traditions alive and respected. Traditional cultural expressions are the artistic and cultural forms passed down through generations within indigenous or local communities. These include music, dance, art, symbols, performances, ceremonies, crafts, stories, and even architectural styles. They are deeply connected to a community's identity and values. Legal protections for these expressions are quite complex. They mainly fall into two categories: defensive protection and positive or offensive protection. Defensive protection works like a shield. It stops others from claiming exclusive rights over cultural expressions they do not own. For example, laws in the United States prevent non-indigenous groups from registering trademarks or copyrights that misuse or misappropriate these cultural forms. This helps prevent unauthorized commercial use or exploitation. Positive protection, on the other hand, gives the communities themselves the rights over their cultural expressions. It recognizes them as the rightful owners. This includes moral rights like the right to be acknowledged as the source of the cultural expression and the right to prevent others from making disrespectful changes. If someone uses or distorts a community's cultural expression in a way that harms its integrity, the community can seek legal action. Some traditional cultural expressions can be protected through existing intellectual property laws. For example, copyright law can protect traditional performances or stories if they are adapted or recorded in a new way. Trademarks can identify authentic indigenous arts or crafts, helping consumers distinguish genuine products from copies. Geographical indications protect products linked to a specific place or culture, like certain textiles or foods. However, these laws often don't fully cover the collective and intergenerational nature of cultural expressions. Because traditional cultural expressions are so deeply tied to communities and passed down over many generations, some countries and organizations are working on special legal systems called sui generis laws. These are unique laws designed specifically to protect cultural expressions. They recognize collective ownership by communities and aim to fill the gaps left by standard intellectual property laws. International treaties also play a role. The Berne Convention protects unpublished works with unknown authorship, which can include some cultural expressions. The Beijing Treaty on Audiovisual Performances grants rights to performers of traditional music and dance. Recently, efforts by the World Intellectual Property Organization aim to requiring disclosure of indigenous origins in patents involving genetic resources or traditional knowledge, which can indirectly support cultural expression protections. Despite all these protections, there are still challenges. Many indigenous and local communities face exploitation or unauthorized use of their cultural expressions without benefit or control. Because these expressions are collective and transmitted over generations, standard laws often fall short. For Latino families and communities, understanding these protections is helpful. When engaging in cultural activities or selling traditional crafts or performances, knowing your rights can prevent misuse. It also helps you advocate for policies that respect and preserve your cultural heritage. Protecting traditional cultural expressions is about respecting the identity and history of communities, ensuring their cultural treasures remain as safe and honored for future generations.